And I'm privileged today to be able to announce our speaker. She is Nora Jordan, formerly from the Davis Polk Law Firm in New York. I'll tell you a little bit more about her in a moment. The title of her talk is Hedge Funds and Private Equity Funds. Nora Jordan retired as a partner at Davis Polk on December 31st, 2020, after 37 years at the firm, and after heading the firm's investment management practice for over 20 years. Nora's practice focused on advising hedge funds, mutual funds, private equity funds, and the managers and directors who oversee them. She worked on numerous internal and SEC investigations involving asset managers as well as acquisitions, reorganizations, and restructurings of asset managers. She served on numerous Davis Polk committees, including the compensation and recruiting committees. She is now senior counsel of the firm. She is an independent director on the board of a Fortune 500 public company, where she serves on the audit committee and the nominating and governance committee. Nora is the vice chair of the board of the American Skin Association and serves on the advisory board of the Global Financial Markets Center at Duke Law School, where she graduated from. She is a fellow of the American Bar Foundation. It is a privilege to have her here as a speaker for the Center for Business Law. I should mention that I didn't have the privilege of having Nora as a student, but I did have her younger sister, Julie Jordan, as a student at Case Western. So with that, I'm going to introduce Nora Jordan to talk about hedge funds and private equity funds, and to just welcome Nora to our law school today.
Thanks very much, Juliet. I understand that the attendees today include law students, business students, practitioners, professors, and so bear with me because I'm going to start with the basics, the real basics, and we're going to go from there. So the first question is, I like the background music, that's good. I'm going to start with what is a hedge fund and what is a private equity fund. There is no legal definition of either of those terms. These are terms that are used by the market. And what they refer to is a company. A company is formed like any other company under state law, and the purpose of that company is to invest in other companies. Rather than making widgets, they're investing in other companies. The term hedge fund commonly refers to a company that buys small percentage interests in other companies, up to a majority, sometimes less than 1%, but generally, and again generally, they're not trying to get control. Now there's some activist funds that do that, but generally they're not. A private equity fund, on the other hand, invests in other companies, but generally takes more than a majority, and most times 100% of a company. So that's what the funds are. Now you say, well, that hedge fund sounded a lot like a mutual fund. Like, isn't that what Fidelity and Vanguard do? They form funds, and they invest in small percentages. What makes private funds different than mutual funds is they're not registered under the Investment Company Act of 1940. And the Investment Company Act, and I'm saying company, remember that because we're going to talk about the Investment Advisors Act later. The Investment Company Act is a very detailed statute with lots of rules and regulations. And that has to be complied with by mutual funds. And it has rules on what you can invest in, who your board is, how much debt you can have, all kinds of restrictions, and restrictions on certain types of compensation, which hedge fund managers and private equity fund managers do not like. So how do they avoid all those regulations? Private funds rely on one of two exemptions in the Investment Company Act. One is 3C1 and one is 3C7. 3C1 is an exemption for a fund or a company that has less than 100 investors. It was originally put there to allow a manager to invest for friends and family without registration. So that's 3C1. 3C7 is an exemption for funds that have sophisticated investors. And I'm just using the term sophisticated, that's not what it says. The way that the Act defines sophisticated is by how much money you have. Now, some people would say those don't always correlate, and that's definitely true, but that's what we've got. So if you're a fund that has more than 100 investors, you need to rely on 3C7, and that means all your investors have to be qualified purchasers. And qualified purchasers means the individuals have to have 5 million of investable assets and companies 25 million. So most of Davis Polk's clients rely on 3C7. They're large hedge funds. They don't want to limit themselves to 100. They rely on 3C7. Sorry, this isn't working. We lost our AV guy. He said, just press the button. And it's not moving. I will keep going anyway. Why are these funds important? Can you click it for me? The reason they're important are numerous. I mean, one issue is they are huge drivers of the market. They have a huge number of assets. Hedge funds were estimated in the second quarter of 2021 to have $4 trillion worth of assets. Private equity had $4.4 trillion worth of assets at the end of last year. So they're huge. And what does that mean? If you're a hedge fund and you're trading that amount of assets, or hedge funds as a group trading that amount of assets, you could affect the market. And you are going to be a big client of the investment banks, the Goldman Sachs, the Morgan Stanleys of the world. You're going to be a very important client of theirs. So they get a lot of publicity and they get a lot of attention. And even if you're a private equity fund where you're not trading securities, you're buying companies, you're taking those companies public, you need investment banks. Investment banks are consultants, they're taking the company public, they're underwriting. And so on Wall Street, at least, hedge funds and private equity funds are hugely important. There also has been, and you may have heard some of this, that hedge funds are very evil. If you watch Billions, which I love, you would also think that hedge funds are pretty evil. And there was a lot of talk for a while that hedge funds actually were a major cause of the financial crisis in 2008. They said the hedge funds were shorting Lehman stock, and they caused the whole collapse. And so I won't go into the whole history of regulation of these hedge funds, but there was less regulation before the financial crisis than after. But I will say that the studies after the financial crisis have not shown that hedge funds were the cause of the crisis. In fact, a lot of people think that it was Morgan Stanley, not Morgan Stanley, it was competitors of Lehman who were actually shorting its stock. And so, who knows? But hedge funds did get further regulation. I'll talk about some of that regulation in a minute. Another reason that they're getting a lot of attention is pension funds. Although, as I said, funds can only be sold either to less than 100 investors or to sophisticated investors, pension funds are considered sophisticated investors if they have $25 million worth of assets. So that means the pension plans of a lot of Americans are invested in hedge funds and private equity funds, and that's caused a lot of congressional interest, and what are these pension funds investing in, and are they risky, and are they environmentally conscious, and all kinds of issues relating to the fact that most Americans actually are invested in hedge funds or private equity, whether they know it or not. Increased activism. Some of the hedge funds have become activists and are going after companies, and of course that gets a lot of publicity. And then the tax treatment of carried interest, a very hot topic right now. One of the differences between a mutual fund and a private fund is the fees that are charged. A mutual fund will charge, let's say, if it's an ETF, it might be 0.2% of assets, and it might charge up to 2% if it's a very risky or a non-US company, but generally they're under 1%, and that's it. There's a management fee, that's it. The fee is based on how many assets are in the fund. Hedge funds and private equity funds charge a management fee, generally 2%, can be more, can be less, but generally 2%, plus they get an incentive fee. And what that is they get 20% of the profit that the investor makes. So if an investor puts in $100, and it turns into $200, they have $100 profit, $20 goes to the manager. And that's the incentive fee. And the question is, how should that fee be treated in the hands of the advisor for tax purposes? The management fee is just fee income, it's ordinary income. The incentive fee, the advisors argue, is really like an investment they made along with the client, and so that should get capital gains treatment if it was held for more than a year, like any other investment. A lot of other people say, no. That you didn't put any money in, that should be treated as ordinary income. And so for every election for the last, I don't know how many years, every politician has said they're going to get rid of this loophole. And people from Trump to Clinton to Biden have said they're going to get rid of it, but that has not happened. What has happened instead, the last time there was a change in law, they changed it from, instead of holding it for 1 year to get the special treatment, the capital gains treatment, you had to hold it for 3 years. And the current proposal is they're changing it to 5 years. I don't know if that'll go through. I don't even know if that's the latest from today. But it's still on paper that they're going to get capital gains treatment on the incentive fee. And this really applies to private equity, not hedge funds, because again, you have to hold the investment for a long period of time, and hedge funds generally don't do that. It's only the private equity funds that do that. So those are some of the reasons that they're getting a lot of attention. There's probably many more that you can think of. And so what laws apply? You may have heard sometimes the Wall Street Journal will call hedge funds lightly regulated. Sometimes they call them unregulated. And that's really not true. They are regulated. Obviously, from the Investment Company Act, they have an exemption, 3C1 and 3C7, or else they wouldn't even be called hedge funds or private equity funds. But everything they do is regulated. You know, every purchase they make, they're subject to the Exchange Act, the Securities Act, the Commodities Act, anti-fraud statutes, state statutes, anti-money laundering, pay-to-play. There's all kinds. Every hedge fund and private equity fund manager that we know has a legal department, a compliance department, and they have lots of laws that apply to them. But in addition, and perhaps more importantly, is we've been talking about the fund, the legal entity that makes the investments. But who's making the decisions for that fund? It actually doesn't have any employees. What it does is it has a contract with an entity, an advisor. And the advisor has the employees, and it has a contract with the company to manage the assets. That's where the fees go. The fund pays the manager through this contract the 2 and 20, the 2% management fee, the 20% carried interest. The advisor is regulated. Not all the time, and certainly before the financial crisis, many fewer advisors were registered than are registered now. Again, I won't go through the whole history. It's kind of interesting if anyone wants to hear it later. But almost all large hedge fund and private equity fund managers are now regulated by the Investment Advisors Act. So they're exempt from the company's exempt from the Investment Company Act, but the advisor is subject to the Advisors Act. And that's basically what I'm going to be talking about today, is the Advisors Act when I get through the few introductory slides. The Advisors Act actually applies to all advisors, big, small, doesn't matter. The anti-fraud provisions apply. There are exemptions from registration in the Advisors Act for certain types of advisors. So for venture capital funds, for family offices, for certain funds that are subject to the Commodities Exchange Act and things like that. The ones that aren't exempt and are over 150 million are subject to all the registration requirements and a lot more requirements in the Advisors Act. So again, virtually all of our clients are subject to the Advisors Act and all the requirements that are in there. And that means they have to have a compliance officer, they have to have a compliance program with the Code of Ethics, they have to have custody and record keeping, and they're subject to SEC inspection. Those are like the basic things, but what really is important is these anti-fraud provisions that I'm going to talk about. They also have to file a form with the SEC. It's called Form ADV. Every registered advisor has to file that. And then, because after the financial crisis, the SEC was being asked questions by Congress, like, what are these hedge funds doing, and are they trading in Lehman, and so forth. There's now another form that has to be filed called Form PF, for private fund, that describes what you're investing in. Because at the time, the SEC wasn't able to say, well, we don't know. They're exempt from the Investment Company Act, so we don't really have information about them. So now they do. All right, the next couple slides are more detail on fiduciary duty, so I'm just going to go through them quickly, although I'm going to come back to that. So again, the Advisors Act, as I said, is the relevant statute for hedge fund and private equity fund managers. And if you get anything else out of this, get the difference between the investment company and the investment advisor. Even the Wall Street Journal and the New York Times get that wrong. They'll talk about Apollo being a fund. Apollo is the manager. The fund has a totally different name. It's managed by Apollo, and it's an Apollo fund. But they're two different things, and that's important. Particularly, if you're going to make an investment in Apollo, what you're investing in is a company that's got a fee stream. That's what you're investing in, this fee stream. If you're going to invest in an Apollo fund, you're investing in the companies that the Apollo fund is investing in. So it's important to know the difference, and people confuse the company with the fund frequently. But going back to the advisor, sometimes called manager, there are two. The Advisors Act is not like the Investment Company Act. As I said, the Investment Company Act is extremely detailed. all kinds of rules about what you can do and what you need to disclose and all that. Advisors Act doesn't have very much of that. It has two key provisions, 2061 and 2062, and they're called anti-fraud provisions. So 2061 says you can't intentionally commit fraud on your clients. Sounds pretty good. Section 2062 says you can't, and I'm rephrasing to give you the substance of it, you can't negligently do something that would act as a fraud on your client. And you think those would be easy to comply with, but the interpretations, and I'll talk about those in a minute, they're kind of developed over time by enforcement actions and SEC kind of pronouncements. And when we're settling actions with the SEC, we always try to settle the action under 2062, because that's the one that says we were negligent in allowing X to happen. Because if you're a manager, the last thing you want to do is report to your clients, oh, we settled this action with the SEC under 2061, where we had to agree that we deliberately, with scienter, defrauded our clients. That is not a good marketing strategy. So most of our clients do not settle actions under 2061. They're mostly under 2062. I mentioned at the beginning there is a fiduciary duty that the advisor has to the fund. And the question is, what does that fiduciary duty mean? Like, what does it entail? And first of all, the word fiduciary duty is not even in the Advisors Act. But what happened is, in SEC versus capital gains, the SEC said there was a congressional intent to impose a fiduciary duty, and they read into 2061 and 2062 this fiduciary duty. And they give a definition, affirmative duty to act in good faith, a duty of loyalty, but again, who knows what that means. And then the Supreme Court said, there is that fiduciary duty, but there's no private right of action. So if you're an investor in a fund, you actually can't bring an action under 2061 or 2062 against an advisor. Only the SEC can do that. If you're an individual, you have to sue under the contract and say, you promised me you'd do X, Y, or Z, and you didn't do it. And then the next question is, okay, well, who is this fiduciary duty owed to that you said I have? Because what if I have a fund and I have tax-exempt investors, and I have taxable investors, and I have risk-averse investors, and I have other people who want to take risks, and like all these different entities, and U.S. and non-U.S., who do I owe the duty to? It can be different. And the interpretations have said you owe the duty to the fund. You don't owe it to the individuals. And so, as I'm going to talk about later, that's why what the fund tells investors it's going to do is extremely important. Because you can say in your fund, I'm going to invest in all taxable, I'm going to invest in totally risky investments, I'm going to, whatever you say, as long as you do it, you're okay. And we'll talk about the extent of the disclosure and did you disclose enough later, but it's all about the document and what it says. Particularly because the fiduciary duty is owed to the fund to do what you said was in there. Now the SEC, although they have held to that interpretation that the fund is the client, they have also found that sometimes it was a little difficult to bring an action against the advisor for something it did vis-a-vis an investor. So let's say I'm the advisor, I have this great fund document, I followed what was in the fund document, but then there's this piece of paper over here where I told this investor, you know what, I'm going to get you 50% returns. And it was in a separate marketing document. I only sent it to maybe 1 or 2 investors, and then that's it. So the SEC passed this rule, 20648, which actually prohibits any untrue statements to investors. So they can now take enforcement action against an advisor for something it did vis-a-vis a particular investor. And there was kind of an uproar at the time by advisors saying you're imposing a fiduciary duty with respect to the investors, and now we're not going to know what to do. And the SEC actually made it clear in the rule, we're not imposing a fiduciary duty, we're just saying you can't commit untrue statements. And they also said there was no private right of action under that section. The next issue really, I think I'll skip over, not go into too much detail, but what it relates to is the difference between federal law and state law. And I know some of you will be more interested in that than others. But I just described everything under federal law. And of course, we have some smart investment advisors out there, and they come to me and they say, okay, I get it. I have this fiduciary duty under federal law, and 2061 and 2062, and only the SEC can come after me for those. Let's make sure that the contract doesn't impose those duties on me so that I don't mind investors suing me because I did something wrong, but let's not like get into this whole anti-fraud and what does that mean, a fiduciary duty. So just say in the contract I don't have a fiduciary duty. Can't do it. Because the SEC says you have a fiduciary duty to the fund, and it's a violation of your fiduciary duty to put a provision in a contract that says you don't have a fiduciary duty. So you definitely can't say that. And most people weren't actually trying to say I have no fiduciary duty. They're trying to do things like say I'm only responsible if I'm grossly negligent as opposed to negligent. And so the law has kind of evolved in this area, and where we've kind of ended up is the SEC has said you can say in your fund document that you're only responsible for your gross negligence if you have sophisticated investors. If you have retail investors, then you have to say negligence. And even though individuals can't sue you on that, we can come in and we can see your contracts, and if you have contracts that violate that, then we can come after you, and they do. And so I put in the slides, let's see, of sample provision if anybody needs it, of what you can put in your contract. And one of the things that we actually put in sometimes to make it very clear that we're not trying to do anything that's not allowed under federal law is you put in a sentence that this section should not be construed as relieving or attempting to relieve any indemnified person from any liability under circumstances, you know, that it would not be in violation of federal law to do so. And a lot of this language has been vetted by a lot of lawyers, and I think the SEC does like to see that because it puts the investor on notice that even though it says, you know, my liability is limited to X, maybe I should talk to a lawyer about this and see what liability there really is. And in fact, there's in the last bullet there, you'll see you can even put a sentence at the end. Each client is strongly encouraged to consult its own legal counsel before assuming that any claim or right has been waived by this provision. And so we actually tell clients to put that in, and usually they're fine with that. So now I'm going to come to more of the practical aspect of this. We talked about the fiduciary duty and what does it mean, and that has not been clear. I can tell you a few things. I can tell you that the SEC did a survey of a whole bunch of people. I can't remember how many. It was an enormous number of people, and 97% of them said they did not think there was any difference between the duty that a broker had to a client and the duty that an advisor had to the client. And that is not true. An advisor has a fiduciary duty, a broker does not. And that's been a subject of much debate. They're actually some people are trying to get brokers to have a fiduciary duty also. A broker only has to offer you something that's suitable for you. Like if you're risk averse, they shouldn't be putting you in risky investments. But they don't have the fiduciary duty to sort of find you the best investment. And even an advisor doesn't have to find you the best investment in the whole world. I mean, there's a million investments out there. But when an advisor looks at a number of investments, he's supposed to pick the best one for you and not consider something that is going to benefit him. And that's not necessarily true for your broker. The advisors, actually, some of them are lobbying to have the brokers have this duty, but so far it hasn't happened. So some of the day-to-day issues that came up, and I was, you know, my whole job was answering questions from hedge fund, private equity fund managers about can I do this, can I do that, or what should I put in my compliance program to make sure that we don't get in trouble over these issues. So I would say at least once a week I'd get a question on allocation. So this is the issue. Hedge fund managers don't just, and private equity fund managers don't just manage one fund. They manage lots of funds. So let's say I've got a fund, and Fund 1 invests in U.S. securities. Any kind of securities, as long as it's based in the U.S., it's eligible for that fund. Fund 2 just invests in tech stocks. That's all it does. So I'm the portfolio manager. I hear about this fantastic tech company, and I really believe this is going to be the next Apple, and it's going to be fantastic. And I'm trying to get a whole bunch of it, and I can't because everyone wants this company, and I don't have enough to go to both funds. So which fund do I give it to? Like, well, Fund 2, the tech fund, has done really well this year, great performance. Fund 1, it hasn't done that well. You know what? I think the fair thing is give it to Fund 1. That'll help its performance. And then in the end, I'll have good performance for both funds and all my investors will be happy. That is a violation of law. You cannot do that. Because from the point of view of Fund 2 investors, like, you didn't tell me you were going to take tech funds and tech companies and give them to somewhere else. The reason I invested in tech is I knew it would do better. So now you're taking investments. I made a decision to invest in tech, and you're taking these investments and giving them to another fund just to help their performance. You never told me that was what was going to happen. Similarly, you can't give it to Fund 1 because Fund 2 says, hey, I was supposed to get tech stocks. You never told me you were going to, give them to Fund, or vice versa, sorry. You never told me you were going to give all the tech funds to Fund 2. You told me you were going to invest in a broad panoply of US companies, including tech. So the problem there is you had to have disclosure up front about what you were going to do. And you can say anything you want. You can say, I'm going to do it pro rata. You can say all the tech goes to Tech 2 before Fund 1 gets it. You can literally write anything you want as long as you follow what you said you were going to do. And we've done allocation policies that are a page long, and we did one policy that was 27 pages long because the client said, well, if it's sourced in this country, I want it to go there, but then if there's some left, I want it to go to this country, and then if there's some left, I want it to be spread over these real estate funds, and it just went on and on and on, until finally at the end it said, if there's anything left after that, just do it randomly. So, but again, as long as they follow and you tell your clients that's what you're going to do. So allocation is a really important issue, and it comes up quite a lot. Another issue that's been very closely watched by the SEC is the relationship with brokers. As I mentioned, these funds and fund managers are very important clients of the brokers. So if I'm a big broker, I'm going to be out there trying to schmooze all of these managers and say, send me your execution, and I can get you to the Super Bowl, and I can give you tickets, and I can do all kinds of things. And they do that, and they very much try to get the business. They hold seminars, they provide technology to them, and that can create a conflict of interest, right? I mean, the advisor is getting all these benefits, but the fund, which is a separate legal entity, is the one that's paying the fees. So you have to make sure that the fund is not overpaying in situations where the advisor is getting these benefits. And I had one case, a very, very large hedge fund manager, billions under management, and the SEC was in, and they saw that he had actually gone on a private plane to the Super Bowl and sat at the 50-yard line, and it was all paid for by a broker. And the examiner was quite upset about this and was talking about taking enforcement action, and this billionaire hedge fund manager said to me, like, you gotta be kidding me. You think I'm gonna make a decision for this fund based on this trip that's probably worth $80,000? And I'm like, I really hope you don't say that to the SEC guy who probably makes less than $80,000. You have to keep this in perspective. And also people do things for small amounts of money even when they're very rich. So you have to be very careful. And the dollars involved sometimes are much greater than that. They can provide research to the advisor, and they provide technology, and so you have to disclose it. You have to tell your clients, I'm getting these benefits. And then you either say, and so I might overpay you might overpay for execution, or you say, I'm not going to, but you should know that this is happening. But the disclosure is key. And maybe it's a good time to talk about we talked about the fiduciary duty, but in 99.9% of the cases, the question is whether it was disclosed. And that's because the SEC wants to bring these cases under 206.1 and 206.2, both of which say you can't commit fraud. It is not fraud if you tell the client. So literally, I was talking to Juliet earlier, like if you say to your client, I'm gonna take $1 million out of your account once a year until I have depleted your entire account and I've taken all your money. If you disclose that, the SEC can't bring an action under the anti-fraud provisions. You did exactly what you told the client you were going to do. They knew you were going to do it, and they still gave you their money. So disclosure is the answer to 99.9% of the questions you would get from a hedge fund manager. It does get more complicated because sometimes I don't have disclosure, so how do we do it? And maybe I'll talk about that actually now before I talk about more examples of conflict questions that come up. If you don't have disclosure, it can be tough. A manager will come in and say, I want to do X, and I really think this is in the interest of investors, but there is this conflict. And I didn't say anything about it. It never occurred to me that this might come up. What can we do? And so sometimes, depending on the facts, what we say is, okay, if you're a hedge fund, clients can get out every quarter. And so why don't you say to clients, send out a disclosure now, because sometimes they want to send the disclosure out after, and you're like, well, that doesn't, the client already invested, how's that going to help them? So what you do is you say, you can get out at the end of June. This is what I'm going to do on July 1st. If you don't like it and you don't agree with it, pull your money out. That is a little coercive, and so we don't want them to do that when certain things happen, but it does give the advisor a leg to stand on to say, look, I disclosed this to my clients and they were okay with it. They stayed in. Because one thing you can't do in most cases is get consent from every single investor. Because you have too many investors, it takes too long, it's not practical. By the time you do all that, the whole investment is gone. So the disclosure, if you don't think of it up front, you sometimes can deal with it on an ongoing basis, as long as investors have the right to pull their money out. All right, let me talk about some other day-to-day conflicts that come up. Client involvement in transactions. This is something that the SEC looks at too. And they can be quite aggressive on this. I'll talk about the Guggenheim, which I thought was a little aggressive. So the SEC is worried that you have favored clients and that you're treating some clients better than others. And this is particularly true in the private equity context, because what happens in private equity is the fund is going to make an investment, but it's not going to put all the money up. Maybe it's going to buy 80% of the company because many reasons. They don't want that much of the fund to be exposed to one particular company. They don't have that much money. It could be a lot of things. So they're looking for someone to go in with them, and they need someone to come up with the 20% for the rest of the company. So what they do is they go out to their investors separately. They have the fund, and then they say, hey, you guys, any of you have some extra money, you can come on in and buy the 20%. And that's called co-investments. And these co-investments are quite attractive. They sometimes have lower fees, they get some other benefits. And so the SEC is concerned that they're giving the co-investments to favored clients. And if they are, they need to disclose that. So what happened in Guggenheim was a Guggenheim executive borrowed money from one of its clients, about $50 million. It was at market rates. He repaid the loan. He used it to buy an investment. There was no issue actually with the loan by itself. And the SEC said, you know, that could have given you a bias. You could have favored that client over other clients. We have no evidence that you did that, but nonetheless you could have, and so you should have disclosed it. You should have disclosed that you get loans from time to time from investors. I think this was a very aggressive position on behalf of the SEC because there was no evidence, at least in the orders, that there was any problem. But it shows you the extent the SEC will go on disclosure. Like any kind of relationship with particular clients has to be disclosed. Martin Curry, even though that was our client, might be a little clearer. So in Martin Curry, and they were a client only after we were trying to settle with the SEC. We did settle with the SEC. We didn't give any advice about them doing this. And the facts are complicated, so I'm going to simplify them. If you read the case, you'll see it's a lot more complicated. But the basic story is this. Portfolio manager running a mutual fund, and he's running a hedge fund. The hedge fund has invested in debt in a bunch of companies. Financial crisis hits. Hedge fund, everything it owns is frozen. He can't sell anything. It's just completely frozen. Investors in hedge funds have a date that they're supposed to get their money, and they're like, give us our money, give us our money. And he's like, I can't give you your money, I can't sell anything. And if I sell now, I'll get like pennies on the dollar. I just can't do it. So the investors were clamoring, they were getting very upset. During the financial crisis, no one knew what was going to happen. So portfolio manager has the mutual fund, which has some cash, make an investment in company X. Guess who owns company X? the hedge fund. So the company takes the money, pays off the debt that's owned by the hedge fund, and then the hedge fund was able to pay out its investors. So the SEC comes in and they say, wait a minute, this mutual fund made this investment, direct investment in the company, and that benefited your hedge fund. There's no allegation that that mutual fund paid too much, that it paid anything other than market price, but the SEC said you would not have made that investment but for your other client, and that is inappropriate. Now, the fact that that mutual fund investment lost virtually all its value did not help the case. Even though there was no allegation at the time that it was an inappropriate investment, it did lose money. And so the SEC said, if you were going to make decisions based on your other clients, then you needed to tell people that. So that's another example of sort of one client decision affecting another. Of course, compensation arrangements, I think these are pretty clear, but there's settlements about them all the time. You know, if I'm an advisor and I'm making an investment in a company and I'm getting a separate commission, or someone's giving me a fee to make this investment, or a kickback or whatever, that's inappropriate unless you tell people that you're going to be doing that. But yet, people do it all the time, and there are many enforcement actions relating to undisclosed compensation arrangements. Affiliated transactions. A lot of funds use a lot of service providers. You know, they have to have their own financial statements. They have to have their own lawyers who help them do deals. They have a lot of service providers to the fund. And sometimes the manager has an affiliate that it wants to use. So it can use the affiliate for managing, you know, custody, for doing administrative work. And so the question is, well, the advisor is supposed to be hiring these people for the fund, and it's negotiating the fees. You know, isn't that a conflict of interest? And yes, it is. And so you need to disclose that you're going to be using affiliates for certain services, and you need to make sure those fees are fair, unless you're going to specifically disclose what the fees are. And if you specifically disclose the fees, then you can't raise them. So you have to be very careful when using affiliates for the fund, because that is a conflict of interest. Employee ownership in portfolio companies. I think the BlackRock case is kind of interesting. So BlackRock is actually, this was a mutual, I think it was a closed-end fund, but a registered fund. But the same principle applies to any fund. So the portfolio manager, he and his son had invested in a company they thought was great. Fabulous company, and actually it ended up doing quite well. And he said, I'd really like to make this investment for my fund. I really believe in this company. He went to the compliance officer and he said, hey, I want to make this investment, but I have this interest and I know that's conflict. You know, do you think it's okay? Compliance officer looks at it, he does a little due diligence, and he says, yeah, it looks like this is a real company, it's totally legit, you know, I see nothing wrong with it, go ahead and make the investment. So the SEC took enforcement action against BlackRock and the CCO, not the portfolio manager. And the reason for that is the SEC said that was a clear conflict of interest that investors should make a decision about, not the CCO. An investor needs to decide whether they're comfortable with a manager investing in companies that he has an interest in. And the CCO should not have done that. So there were a lot of CCOs who got very upset about that, but in my view, it's not an unreasonable position. You need to disclose it. You need to tell people that you're going to do that. So that was BlackRock. Another issue is personal trading, because this one's interesting, because a lot of times advisors think, well, if I'm doing something that doesn't hurt in any way the fund, why can't I do it? But this is where the fiduciary duty kind of comes in, which whatever it means, it has been interpreted as meaning you can't benefit yourself, even if it doesn't hurt the fund. So for example, I'm a big hedge fund manager. I'm going to make this gazillion-dollar trade tomorrow. It's going to affect the market. The price of my security is going to go way up. And so I'm going to make a little investment for myself today. What I do today is not going to affect what the fund does. I'm just making a small investment. But what will happen is when I make the big trade tomorrow, what I bought today is going to go up. So I'm going to benefit for myself when the price goes up. That's called front running, and that is illegal. You can't do it. And so most hedge fund managers have, a window where you're not allowed to trade before and after a trade. And it's part of this whole fiduciary thing. And this is one of those things where you say, well, if I disclosed that I was going to front run, could I do it? And this is where the intersection between fiduciary duty and disclosures come a little bit into conflict, a little bit unclear whether the SEC would actually let you do that if you disclosed it. I have a client who's one of the biggest hedge fund managers in the world. Actually, I have two that are in the same boat. And I'm not going to say their name, but if you read about it, there are a lot of articles about this. So both managers do quantitative trading. They have rooms full of computers that make decisions on investing. There's nobody analyzing companies and saying, this is the company I think is going to make money. It's all about, did the stock go up or down? It can be about cloud cover in New York means you should buy umbrella companies. It's like crazy stuff. They call them signals. And they have PhDs who create these signals, and then the computers generate the trading. So you have a strategy that's kind of encompasses these signals. And there's limited capacity. So you might be able to trade 1 billion using this strategy. But if you do 1 billion 5, there's so much trading that the returns start getting lower. Okay. So what these two managers do is they create a fund. They put all their money in it and all their employee money in it, no outside investors, and they follow that strategy. Then they create a second fund, and they say, okay, client, you can come in this fund, but let me tell you, our fund's going to do way better than yours. And actually, some of the things we do might affect your fund. We have disclosure all over the place about this, telling investors in Fund 2 that this other fund is using a different strategy, it's trading more frequently, all kinds of stuff. And the performance is better, generally. That's intended. And the SEC comes in every time, and they're like, what? Like, you have this fund, and you're trading, and the trading can affect the second fund, and this is outrageous, and your clients, but the clients want to be in Fund 2. They'd like to be in Fund 1, but their second choice is Fund 2, because Fund 2 does really well. Both these are really big hedge fund managers, and they're happy to be in Fund 2. And every time we get a new examiner, and they're in there going, this is outrageous. But then in the end, we're like, well, where did we defer clients? Where did we tell? Everything is laid out here in black and white. We told them exactly what was happening. If you're going to take this position, we're not going to take outside money ever again, and we'll just close up shop. And so the SEC has not taken enforcement action against either of them. But every time you have to go through this education with the advisor saying, look, clients understand this, you can go talk to the clients, and they do. And so again, disclosure can cure a lot. Expenses. So our documents, maybe 15, 20 years ago, used to say, the fund will pay ordinary expenses of a fund, including legal and auditing fees or something like that. Now, our expense sections are pages and pages long, listing every expense you've ever heard of that we want the fund to pay, because the SEC is all over expenses as something that they really care about and really want to be disclosed. And there are some reasons why they should say that. Let me see. I'll talk about the TPG one. It's TPG, but there were actually quite a few advisors who had the same issue. So in addition to 2 and 20 that advisors get from the funds, they also charge some other fees. And one fee was called a monitoring fee. This is, you have a private equity fund, and it says, we're going to have to closely monitor each of these companies. We might have someone on the board of that company. So we're going to charge you another fee for monitoring that company during the whole period that we own it. That's okay. They disclosed it, told everybody about it. You might think, isn't that what the 2 and 20 is for? But anyway, they disclosed it, so it was fine. But what happened was, normally they would hold those companies for, say, 5 to 10 years, but occasionally they would sell one earlier. So let's say instead of holding it that long, they sold it in year 3. And they said, well, we're selling in year 3. We would have gotten all those monitoring fees if we'd held it for 7 years. We're going to accelerate the monitoring fee and charge the monitoring fee now during the sale and keep that money for ourselves. Now, if you talk to the investors in funds, virtually every investor knew that was happening. It was understood it was happening, but nobody had it in their documents. No one had the acceleration of those fees in the documents. So the SEC took enforcement action against a whole bunch of advisors. And again, this goes to, is the disclosure sufficient? You know, sometimes people think, well, it's minor. Like, you can have $1 billion fund, and I start charging the fund for my babysitter. Small amount, doesn't matter. That is an expense that an investor would not expect to be charged. So the SEC takes a view, if it's something a client wouldn't expect, you better list it specifically. They also take the view, if it's an amount, even if it's something they would expect, if it's an amount that's way higher than one would expect, you have to list it. And in the case of monitoring fees, they said, well, you disclose monitoring fees, and maybe you're saying that investors knew that it was going to be accelerated, but I don't think so, and you should have disclosed that aspect of monitoring fees in the document. And people hadn't done that. So there was a lot of uproar when the monitoring fees happened, because I think the advisors felt like everybody understood it, but it didn't matter. Disclose it. And I think people would have if they had thought about it. Another, KKR had an issue that a lot of other big private equity funds also had, and this is called the broken deal expense rule. So I'm KKR, I'm making this big investment by the fund, and let's say once again, I need some co-investors. But the first thing I'm going to do, I'm going to find an investment, I'm going to hire lawyers to look at it, I'm going to do due diligence, I'm going to hire consultants, I'm going to, all kinds of stuff. I spend a lot of money, and then I decide, okay, I'm going to make the investment. It looks good, pass due diligence. So I form the fund, my fund invests 80%, co-investors invest 20%, and we all share the fees. That's fine, no issue. All right, now investment number 2 comes along. I hire all these people, I pay all these costs, and then I decide I'm not going to make the investment. I charge my fund for the fees, the expenses, because I don't have co-investors. I didn't go to them. I didn't have an investment to bring to them. And the SEC said, wait a minute, you should have disclosed to the fund that they were only sharing these expenses of due diligence when you had a co-investment. Now again, some people thought that was obvious that that was going to happen, but once again, and I think part of it was that a lot of times they had the same co-investors, and a lot of times the co-investors were employees of the advisor, so it looked bad. It looked like you were really charging the fund for expenses that maybe the employees and some other people could have charged. So it did have some, you know, hair around it. Let's see. Okay, the Blackstone. This is another one that other people had. Yes, you see the answer all the time is disclosure. Blackstone, big private equity firm, hired a law firm to do all their legal work, and the funds were paying this law firm, one of our competitors, we actually represented the law firm in this SEC settlement, but the law firm was getting tens of millions, if not more, for doing the legal work for the funds, because you have to set the funds up, you set compliance programs, you help the fund negotiate with all the investors, you do questionnaires to make sure they're eligible, that they're actually, you know, rich people, rich companies, they're fitting the requirements. It's a lot of work. So the advisor, Blackstone, went to the law firm and said, we're sending you a lot of work from our funds, and you know, you're doing some work for us, and we think you should cut us a break on your legal fees when you're doing work for us, for BlackRock. And so the law firm gave them a big discount when it was work for the advisor, but not when it was work for the fund. And the SEC came in and said, wait a minute, that is not right. The fund is the one sending all the work. The fund is paying it. You, the advisor, should be negotiating a discount for the funds, not for yourself. And so you either need to charge the same thing or you need to give it to the funds. And so it was a settlement over that. And that was not an uncommon thing. I want you to know we never did that. But some law firms were agreeing to do that. Let's see. Gifts and entertainment, I talked about a little bit. That's sort of obvious if you're giving gifts to the advisor, same kind of issue. Okay, I'm going to move to a slightly different topic. A lot of this was about conflicts and about the anti-fraud provisions. And I mentioned that the Advisors Act has very few provisions that specifically restrict you, the advisor from doing something. It's just anti-fraud. You got to do what's right. But there is a provision called 2063 that covers what Congress considered to be the biggest conflict of all. And that's when the advisor is on one side and the fund is on the other, and you're buying or selling something between them. Because they said that's just such a big conflict. For yourself, and you're selling something, you want to get the highest price, but for your fund, you're supposed to be negotiating the lowest price, and that's just too big a conflict. So disclosure does not cure a principal trade, it's called, a 2063 trade. What you have to do is you have to get consent from the client. And you can't get consent up front in the documents. Like, say, I'm going to do a lot of principal trades in the future, you have to agree to this. You can't do that. You have to get consent for each trade. And you have to give disclosure that's sufficient that the client can make a decision. So you have to say, this is how much you're going to pay, this is what the market price is, and if there's no market price, this is what the appraisals are. You have to give enough information that the client can make the decision. And principal trades don't happen that much, partly because of this, because clients, advisors, don't want to go to their clients and say, I'm buying or selling this, because it just sounds a little fishy. But sometimes they do, and I do a lot of work on 2063 transactions, because it sounds fairly simple, but it's not, because first of all, now I'm dealing with a fund. How do I get consent from a fund? Is it a majority of the investors? Is it all the investors? What do you do? And so what we do is we try to set up a mechanism when we set up the fund from the beginning. Also not so easy. What you really want is you want to take some key investors and say, you'll make a decision for everybody. Sometimes that'll happen. Sometimes investors are like, I'm not taking responsibility for all these other people. I don't want that liability. Sometimes you do an independent board who makes the decision. And there's like a group of directors in Bermuda who will do principal trade approvals for you. And they do have liability, and in order to satisfy them, you need to get appraisals, and you need to do all kinds of things. But even they don't want to do it very often. They will do it for readily marketable securities or things that are not so risky, but that the advisor would like to do because they think it's the right thing, and so they'll do that. So the consent process can be difficult in the fund context. You can't say that a certain percentage will approve, and if everyone agrees to that up front, that's okay. But then you have to go out, and it's almost like a proxy, and we have done that. We have gone out and gotten the requisite percentage to approve a principal trade. And it can come up in odd situations where you're trying to like combine funds, and the reason that can involve a principal trade is, let's say I'm the advisor, and they all invest in their own funds. If I, the advisor, own, say, 75% of Fund 1, and Fund 1 is going to do something with Fund 2, sell a security, that's a principal trade. Because I have so much of Fund 1 that it's really me, the advisor, trading. And the SEC's position is that if the advisor owns more than 25% of a fund, it becomes a principal trade if that fund is dealing with another client of the advisor. So lots of issues come up on 2063, as you can see. But it is one of the other provisions of the Advisors Act that's actually goes beyond 2061 and 2, the anti-fraud provisions. Pay to play, you've probably heard of that. I'll just briefly, as I said, pension plans are some of the biggest investors in these funds now. And if the advisor is making donations to certain people in a state who control the pension plans, that's a problem. And there have been some enforcement actions along those lines. And so now almost every hedge fund and private equity fund manager, when you're an employee and when you're applying for a job, you have to fill something out asking what donations you've made to make sure that they're not going to be precluded from dealing with that, the pension plan in your state. Performance disclosure, another conflict that comes up under the Advisors Act and where the SEC takes a lot of action. You would think performance would be straightforward to compute, but it's not really. There's lots of different ways to do it, and do you assume dividends, do you assume reinvestment, all those kinds of things. But in addition, if I show performance, let's say I have a fund and I only charge a 1% fee, I actually didn't charge a performance fee because I was just kind of starting and getting it going, or I charged a very low performance fee, and now I have a new fund, and this fund did really well, so now I'm going to charge 2 and 30. If I show the investors in new fund the performance of the first fund, which didn't have very many fees, that's misleading. So the SEC looks at, well, what fees did you charge the two funds to make sure that you're not telling Fund 2 something that isn't quite right? Because if you had charged those same fees, they would not have gotten that return. So you have to be very careful with performance disclosure. And when you see offering memos for private equity and hedge funds, you'll see pages and pages of disclosures. And investors are quite sophisticated. They do read these and go through them. And they sometimes ask for information that you don't even, you feel like, well, that might be misleading. I don't want to give you that and get in trouble. But like, we can't, you know? And so at least some investors are very sophisticated and understand. Like they'll say, well, that fund, you know, engage in debt and equity. Can you take out the equity and just show me the debt? And you're like, well, I didn't just do debt. And so I don't want the SEC to say I'm showing you something I didn't do. Because one thing people get in trouble for is hypothetical performance. And, you know, I could have absolutely fabulous hypothetical performance if, you know, I just look at what did well and say, yeah, these are the things I would have invested in. Like, you can't do that. There are certain things that are more objective, like you can say, well, if I invested in the S&P, I would have gotten X return because we know what the S&P did. It can't be manipulated. But people come up with strategies with the benefit of hindsight, and those you have to be very careful of, because with the benefit of hindsight, we could all do pretty well. Proxy voting. It used to be that people took the proxies and threw them in the trash. Like, that's too much trouble, and especially in a hedge fund, I only have a little piece of that company, and so what does it matter? The SEC came out and said you have your fiduciary duty entails voting for proxies. And so now people do that, and now, of course, with ESG and all kinds of other issues, there's a lot more interest in how those proxy votes are happening and what they're voting for, and you have to report it and so forth. So proxy voting has become much more important. Maybe I'll talk about side letters for a minute. You know, the whole idea of a fund is, I don't want to negotiate with you, and then with you, and then with you, and then with you, and have separate agreements with each of you about what I'm going to do and what fees I'm going to charge. It's too much trouble, and it's too hard to keep track. You don't want tobacco stocks, and you don't want some oil stocks, and I just can't do that. So the whole idea of a fund is, I'm going to create this vehicle. I'm going to tell you all exactly what I'm going to do. I am going to do oil. I am going to do whatever. These are the fees. Take it or leave it. That's the whole concept. And in the mutual fund world, that works. People look at it and they, okay, that's what I'm going to do. You can't call up Fidelity and say, I don't really want you to do that. Well, when you're investing in a hedge fund or private equity fund and you say, I'm going to give you $800 million if you change that to be this, the manager might say, oh, okay, well, 800 million is pretty good. The fees on that are pretty good. Maybe I'll listen to this. And so when you're forming the fund, you talk to the big investors first, and depending on the situation, you might say, all right, I'm going to lower the fees from 3% to 2.5% because I'm not getting the interest so somebody negotiates that and you give it to everybody. Or somebody doesn't want SIN stocks, okay, I'm going to do that because they're such a big investor. But sometimes you say, I'll give it to you, but I'm not giving it to everybody else. And so what you have is called a side letter. You have the fund document that describes everything the fund's going to do, and then you have the side letter that says, this is a special term that applies to you. And the SEC has said, they don't like these side letters unless you tell everyone what's in the side letter. Like, what is the special deal somebody's getting? And again, the extent of disclosure is important there depending on the issue, because some are pretty mundane. Like sometimes people can't invest in certain stocks because they're a regulated entity, and you say, all right, well, you're not going to get any of the returns on X because you're not allowed to. So they can be mundane, but other times they can be quite serious. And the two most serious ones, which the SEC really doesn't like, and which most people won't even agree in a side letter, is on liquidity and information rights. Because liquidity, let's say you're a hedge fund and you can get out quarterly, if you tell an investor they can get out anytime they want, that's a problem. Because if there's another financial crisis, and that investor can come in and say, I want all my money back, you're going to sell all your liquid securities, give it to them, and then everyone who's left is left with all the stuff that can't be sold. And that's not fair. So the SEC really does not like to see side letters relating to liquidity or information rights. You know, you put out your reports on a periodic basis, and you should not be telling certain investors more information than others, because again, that could influence their judgment on redeeming from the fund at a time other people might redeem if they had that information too. I will finish with valuation issues on the last page. There's some other things that you can talk about, you can see in the slides. Valuation obviously is extremely important for many reasons. First of all, 2 and 20. The 2% is based on the value of the fund. The 20% is based on profits. It's a little easier because usually you've sold the asset and you can determine what the 20 is. But the management fee is dependent on the assets. And so the SEC believes, and it could be right, that people are subconsciously biased towards overvaluing assets. And so you have to be very careful with your valuations of your assets. And most people nowadays, if it's a very illiquid security, will get a third party to appraise it. And valuation can also be very important if you're buying and selling securities between your funds. Sometimes, for a variety of reasons, it can be totally appropriate to move an investment from one fund to the other. And so if you overvalue it or undervalue it, that's a problem because then the other fund is not getting the right price. So valuation is very important, and you need to describe your methodology for valuing securities. So I will end on that note. There's a million other conflict questions that come up all the time. It's a very interesting area to practice in if you're interested.
So we might have time for a couple of questions. And I will take any questions from the floor for Nora in person, but Brandon, I'm not sure where he is, there he is, will take any questions that are coming off the webinar. Okay? So, any questions from the floor? Thank you.
Hi, what constitutes a valid disclosure, especially if you're trying to bury things in thousands of pages of documents that you almost hope, if not expect, nobody to really vet properly?
That is an excellent question. I mean, generally speaking, if you have it almost anywhere, you're going to be able to at least make the case that you disclosed it. I think depending on the issue, the SEC can take issue with that. About, was it buried in the back? Was it buried in the front? Was it inconsistent with something else you said? But generally speaking, if you have it in that document, you're going to be on a good road to protecting yourself.
And that includes footnotes?
And that includes footnotes. Not always, not always. The SEC will definitely sometimes say it wasn't prominent enough. Sometimes they actually, in releases, say this should not be in a footnote. Or they'll say it needs to be on every page. Like on the hypothetical performance, you have to label every single page. Hypothetical performance. You can't just put it in the back.
One bookkeeping question can a broker and an advisor be the same?
Yes, and that can create a lot of issues. We actually settled an action last year. We argued that the person who was jointly registered was acting as a broker when he did something, and the SEC argued he was an advisor when he did it. And so we had to settle because they had a little more power than we did. But yes, you can be jointly registered, and it can cause confusion on the part of not only the person doing the activity, but the client. Yeah.
Professor Beck. Professor Ellen Beck.
So first, thank you so much. It's really an honor to have you here with us today. And I know we've been discussing these issues in class. Maybe you can tell our students a little bit more about activist hedge funds, right? And especially with ESG, such a hot topic, and with ExxonMobil and everything that's going on now. Maybe just a little bit about some of them call themselves friendly activist hedge funds, right? Like Nelson Peltz. It's always funny when he always presents himself. I'm a friendly one. I don't know.
Right, he just went after Invesco.
I know.
Yeah, we actually don't generally represent activist hedge funds.
Okay.
Because our clients don't like it. We have a lot of corporate clients, and they don't like activist hedge funds, and so we generally don't represent them.
Okay, that's cool. And do you ever, have you been in a position, because there's a big trend now with mutual funds, right, investing in private entities. They were always able to do that, as you know, and now they invest, it's even less than 1%, right, of their portfolio. And I've talked to a few and to their general counsel, and they said that they're doing that with hedge funds doing the monitoring for them. Were you ever involved in this? Can you tell us a little bit about how that works?
Yes. So this is another reason that hedge funds have gotten a little more attention because, as I said, putting aside the 100 holders, because that's not relevant here, you have to be a sophisticated investor to invest in a hedge fund, right? But now let's say you're a mutual fund and you decide one of your investments is going to be a hedge fund. Is that okay? Well, you look through the mutual fund and they're not sophisticated investors, but you say, well, it's only less than 1% of our portfolio, so that's fine, and the SEC says fine. But we actually had clients who put all their money in hedge funds. So it's a registered fund, closed-end fund, and it takes all of its money and invests in other hedge funds. And it does a diversified portfolio, and so no hedge fund is a big percentage of the mutual fund. Let's say under 10% for now. The number is, I would say, not clear how many funds you're allowed to have in a mutual fund. But let's say that's all under 10%. So we would argue that there's no look-through, that we're not actually offering one of these hedge funds to the public. We're offering the mutual fund, and it's a diversified portfolio. And the SEC has allowed this. So we have funds, registered funds, that invest in hedge funds. And that's the argument. But the SEC says, and this is not in the law anywhere, they say, well, that mutual fund, that closed-end fund, can't be purchased by moms and pops. They don't have to be qualified purchasers, the 5 million, but we think they need to at least be accredited investors. And they won't declare you effective. I don't know if you all know what that means, but they won't let you sell your mutual fund unless you agree that you're only going to sell to people that are accredited investors. And so it's an interesting question, and some people are complaining about SEC overreaching there and would really like hedge funds to be able to sell to the mutual funds. You can debate both sides of that. Hedge funds and private equity funds historically have had better performance than mutual funds, and so some people say, all these pension funds are not able to invest in the best investments, and this is a way for them to do that. So there's two sides. Yep.
Brandon, are there any questions from the queue?
Okay, with all of the disclosure obligations, what special problems are posed by SPACS? SPACs.
That is a 4-hour discussion. I don't even know where to begin with the SPACs. I mean, I don't know if I want to wade into it, but SPACs get a little more flexibility actually in disclosure because they can disclose forward-looking statements. Obviously, they've been kind of a hot topic. Some of the acquisitions have not done very well. The SEC is looking at SPACs. I don't know what to say. Yes, disclosure is important.
Okay. With a 20% incentive on trades, how is churning addressed?
Churning is an issue for the broker. Well, it is an issue for both. But if you're an advisor and you're executing with a third-party broker, you're generating a lot of fees for that broker, but you're not generating those fees for yourself. So churning comes up generally when it's a broker managing your account and they're just buying and selling your securities all the time to generate commissions for themselves. It doesn't really come up in the hedge fund area so much because generally, not always, it's a third-party broker. And so you wouldn't be trying to generate brokerage fees for someone who's not an affiliate.
Okay, I think this one was from a bit earlier, but I'll ask it just in case. Does disclosure remove fiduciary duty?
That is the question. Disclosure gets you 99% of the way there. I've been on a panel with the SEC, and I said to the examiner, if I tell my client I'm going to steal money from you, do I have a problem under the Advisors Act? And he said no. Now, would every person at the examiner think that? I don't know, but it's sort of this example where I said I'm going to take the money, the $1 million out until I deplete your account. I'm basically taking money for no reason. I think it cures a lot.
Do you have any more questions from the floor? Because we're sort of going over now. So should I call this to a close and to just thank you so much, Nora
Okay,
Jordan, for
sure.
coming?